Thank you very much. Thank you, Mr. Chairman, Ranking Member, and thanks to each of you for being here and for being willing to testify and share your experience on this extremely important subject. I want to express again my concern in the growing epidemic of violence, particularly I think youth violence that we're seeing around the country, and I hope that we can look and that this committee and others will look into not just the after the fact results of this terrible violence, but the causes of it, the social causes of it, and including the role of perhaps social media and others in driving this youth violence, which I think is extremely important. I've looked at the different statutes around the country, the 14 different states in the district who have laws like the ones we're talking about today, and they vary quite widely, as we've discussed. And as a former prosecutor, former attorney general, of course, I'm very concerned that we protect the due process rights of all persons involved while keeping weapons out of the hands of those who are criminals, those who are a danger to themselves and others. And that, of course, is a balance we have to strike every day in the law. I mean, we do this in many contexts, not just when it relates to the Second Amendment rights, although the Second Amendment is a fundamental right, as the United States Supreme Court has said. But it is a familiar balancing act we have to perform in the law, and certainly need to perform it here. Mr. Koppel, let me just ask you, I want to come back to something you were saying to Senator Cruz, talking about the differences in these laws. You pointed out that Connecticut, you said you think in many ways their initiation process is an ideal one, and I take it you think that because it requires a state's attorney or assistant state's attorney or a law enforcement officer to initiate the proceedings. Can you just say more about why you think that is a good process that's protective of due process?
Sure. As there are lots of people who might know about somebody who does pose an extreme risk, but and there are also lots of people who might, just as they take advantage of lots of other laws about alleged child abuse or domestic violence and things like that, you know, in ugly divorces and in situations, false accusations do happen, sometimes often. And so Connecticut has, I think, a good filter on that, which is anybody can go to law enforcement and then ask them to initiate this petition. And law enforcement then has two officers or a state's attorney has the obligation to conduct their own independent investigation, and based on that, they go forward. Now, even so, we still have a high error rate, 32% error rate, even with the law enforcement as the filter. But I would suggest that that's probably
that's in Connecticut, 32%.
Yes. Yes, but when you broaden the scope of anybody who can come in for any reason, sometimes with good intentions and sometimes not, that would tend to, I think, make the error rate even worse. And in Colorado, certainly a lot of the legislative testimony we've heard about the bill that's before our legislature has been many women who were in divorce proceedings and said, I'm terrified of this bill because because the Colorado law allows a huge number of people to initiate. And as a woman said, if this bill had been around when I was getting divorced, my husband absolutely would have used it against me. And we've heard that from many, many people. So I think the law enforcement judgment is an important part of practical due process protection.
What do you think are some other states whose procedures across the range here are good models as you look at these laws?
Well, the Colorado law has something. It's not quite law yet, but it's going to be, provides for court-appointed counsel for all respondents. I think that's an outstanding feature, and that's exactly the kind of thing that federal funding could encourage. Vermont does a good job at de-escalating, the popular topic, I think, among everyone on this panel, de-escalating the confiscation process. Instead of having the law enforcement automatically show up and say, ex parte, I'm here to take your guns. Instead, the person who's subject to the order can, rather than having the guns hauled out by the police, can give them to a federal firearms licensee like a gun store or another responsible individual. And obviously that's something that has to be done quite promptly, but it's less confrontational than forcing law enforcement to walk off with someone's guns. Sometimes there are situations where law enforcement absolutely should, but that doesn't always have to be the mandate. That can be more the judgment of the officers and the courts.
Great.